You got any repeat?
Sorry.
Hello. So let me know when we've got your computers are up and running, and let me just address the folks on Zoom now. Folks on Zoom, we are having technical difficulties here, and the state is, only one of the assistant state attorneys is here right now. So I'm not going to commence the morning docket until everything is ready to roll. So please bear with us, okay? Thank you.
I'm in the talk to make sure you got my, I didn't.
Yeah, no, I sure will. Thank you. So just letting you know.
Yep, will do.
Stand in the morning. I got it. Well, or you do, yeah. If you want to read it, yeah. Thank you.
It's just one sleep foot.
And I was carrying my umbrella in my right arm. So my umbrella is apparently, found out this morning.
I see a couple drops here and there, and I can one arm like right at the leg.
Well, it's a hard to get situation.
Hey, see ya.
Those two things.
So did I rephrase that the chief judge said no more masks after the 15th? You can order it. Yeah, I got a copy of that. It said November 15th, the last day.
Wait for our man to say.
Well, that's not gonna happen. Hopefully you don't want to walk around the outside.
School doing 15, so it kind of, that makes sense.
Yeah.
We'll see. You were cool before.
The battle here there between the governor and the president about his, employees that was vaccinated.
We said the January
14. That's right. He's not gonna tell them what to do.
It's Friday. Go back, what you got? Paper clips? When they're green before. That'd be awesome. Throw up with that balance line, right? 'Cause that's the pedal.
Were you able to get talk to them in person?
Some names now you can't have anymore. Can't have Karen, can't have Alicia, can't have Brandon.
No, I would just enter it and then.
Well, names, certain names you can't have anymore. Because now if you have that, you're like, she's a Karen.
I know, I lost Karen and I feel bad. It was like I tried to do her, and I got her to do it, and she like. Faces. Actually, you can start in the. Yeah. No, but we have evidence you're gonna try. And mine.
Direct line. All rise. Court is now in session. Honorable Jeffrey Gillen presiding.
All right, good morning, everybody. Go ahead and take your seats. I think we're gonna be all right, technologically speaking. So for those of you on Zoom, I will take cases in the courtroom first, so I can keep the number of face-to-face contacts to a minimum, for obvious reasons. But I will get to everything on the docket this morning, so please bear with me. And I'm sorry for the delay this morning, folks. All right, let me try again. Let me get Okay, so just let me know if I'm moving too fast or whatever. All right, so what's ready here in the courtroom, folks? Gosh, I give you an extra 10 minutes and we're still not ready to go. All right, so on Zoom, who's ready on Zoom? All right, I'll just go back and take a nap. I'm just kidding, of course.
Judge, this is Cynthia Cohen. I can't see who's in the courtroom. Is Mr. Paris in the courtroom?
He is.
I think he and I have Johann Mervin, who was just sent over from, I may be confusing him with someone else. We have a case that was just sent over from Belgrade. It was filed 2 days ago.
Okay.
I think it's Johann Mervin.
Okay. All right, Mr. Perris is now at the podium. I assume you can now see him. All right, let me, I remember the name, but I can't remember until I look at my notes what the story is. Oh, yeah. Okay, so, there's an alleged VOP. Just, both of you, if you will, right. If you will, please. Hey, Monkey Prick, you want to, take that image off the screen, please? This is serious going on here. If you don't, I'm going to knock you off the screen. Knock them off, please. Thank you. All right, Mervyn, so somebody, both of you, educate me. We've got a VOP on a 2020 case for aggravated battery with a wine bottle, as I recall. And then there's a new case, the 2021 case, which is a alleged felony battery as well. I'm assuming totally different victims, right? I just don't remember.
I couldn't.
You don't remember either? Do you happen to remember, Ms. Cohen?
Judge, actually, I'm looking at the docket now, and the other case was a Dove case. And this one is not a Dove case. And what I mean by that is a domestic violence case. And I didn't know that Ms. Borrego had that other case. In my situation, the victim is the stepfather. And it doesn't, I'm not quite sure if it's domestic in nature. Obviously, I have it, so I'm going to assume different victims.
Okay. All right. That was my impression, but I was unsure. All right. In any event, so where do we stand on this one, the new one?
The new one, it was literally filed 2 or 3 days ago in Belgrade and just sent to me. So I was just able to start looking at it. I haven't even done discovery because it's just a few days old.
Okay, so what do we want to do?
Maybe set it in about 30 days.
All right. For the record, Mr. Mervyn is here. I'm assuming that's Mr. Mervyn. Are you Mr. Mervyn? Yes, okay, thank you. Yeah, all right, so I'm going to recall this one in just a moment, give Mr. Perris an opportunity to talk with Mr. Mervyn. I can, Mr. Fleischman, if you're ready on one, I'll take it.
Good morning.
Good morning.
My brother was gonna do Zoom, but I can do it now.
Okay, which one is
Dudley,
it? I'm sorry, what?
Mr. Dudley.
Dudley, okay, thank you.
For Dudley, we have, his
Thanks.
case is still pending in Broward. This is
Okay.
kind of like tracking it, so we're
Okay,
gonna ask for a 45-day reset. Ms. White is aware of the other case.
all right, and, she's okay with a reset of 45?
Your Honor,
Okay.
I'm sure speedy's waived, right?
Yes.
Okay.
It is, well, no, it wasn't, but it is now?
I'll waive speeding.
Thank you, okay. So, you all tell me, December 17, does that work for you?
That's fine.
That's fine.
Wait, let me just check real quick.
Sure, it's a Friday. Or another Friday.
That is fine. Will you allow Zoom? I may be in another county.
Yeah, listen, in case you're not familiar or aware of it, effective November 15, masks will no longer be required in the courtroom, in the courthouse, I should say. But I'm gonna keep going with Zoom for a time and just see if it makes sense. It seems to move things along pretty quickly, and once we're back in full swing with, jury trials, it might help things. I'll see. I'm gonna continue to use it, and then we'll see. All right, so status check then on Mr. Dudley's case, December 17, with speedy being waived today. All right, thank you. Got another with me this morning, Mr. Fleischman? I don't know if you do, I'm asking. Okay, then, enjoy your weekend, stay safe. All right, Mr. Perris, back to, Mr. Mervyn. Okay,
Yeah, we're setting these court dates in 30 days makes sense. I just need the discovery so I can go over.
okay. So, December 8, does that, work for both, the state and, the defense?
Yes, Your Honor.
All right, 12:08 status check on Mr. Mervyn's, cases, we'll say.
Thank you.
All right, thanks. Okay, I'll scratch that one from now on. All right. And that was Mr. Mervyn. Okay, good morning, Mr. Taub, how are you?
Good morning, Your Honor. I'm well. How are you?
I'm doing well also, thank you.
page 3, I have Catherine Dumont.
Okay,
I entered a DPA this morning for the cost prosecution as well as the drug course. She's gonna need about 4 months to get the money together to pay the COP,
okay,
so we're asking for a date in about a month or so.
all right. So, sometime in March, is that good? That would be about 4 months. Okay, March 4 it is. Does that work for everyone? All right. Okay, great. All right, thanks. Ms. Dumont, make sure you stay in touch with Mr. Taub. All right, thank you. Okay, anybody else ready here in the courtroom? Not yet? Okay, back to Zoom. Anybody ready on Zoom? All right, not yet. So when something is ready, just give me a shout.
I think we can address Brandon Preston on page 5.
Sure. 3, 4, 5. Preston, middle of the page, okay?
Status check, this is a constructive possession case, so the DNA is obviously at issue. DNA files were, given to me this week. We have a forensics attorney on the case who's gonna look at that. I'm asking for a status check in January.
Okay. Is that, are you able to waive speedy?
I can wait, Speedy.
All right, very well. Speedy being waived today. Let me just clarify something. According to the docket, count 1 is actual possession.
Yes, Your Honor.
Yeah.
Okay, all right, very well. Okay, so, and I do remember this, I read the PCA, there were 12 shots fired apparently, shot spotter found them, and there was a handgun. In any event, speedy being waived, and you wanted how much time?
Status check in January.
January, okay. Let us see. Steph, January 7? Okay, January 7 then, if that works for both of you?
That works.
Okay. 0107, status check on Mr. Preston's case. Speedy being waived today, thank you. All right, anything else ready in the courtroom? All right, back to Zoom. Anybody ready on Zoom? Mr. Inskeep? Hi.
Good morning, Judge.
Morning.
I have one case with Miss Black, and that is Michael White.
All right, which one is it?
Michael Waite, W-A-I-T-E.
All right, thank you.
We are here,
Okay, thanks.
we are here for a plea conference, and I was requesting for the court if we could set this for next Tuesday, this upcoming Tuesday, the 9th, for a plea conference.
Sure. All right. 11:09 plea conference on Mr. Waite. Will you notice him, please? I don't know whether we have
I
an
will.
address or not, but regardless, that's kind of short notice.
Yep, thank you.
All right. No, thank you. All right. Stay safe. Bye-bye. Okay.
So is that 11:09?
Yes. Morning, Mr. Casals. Middle of page 3. I'm doing fine, thank you. All right, Lopez, middle of page 3. I see the motion and I saw the state's response as well. I think that honestly, the state's response is well taken. I'm not sure that I have the authority to grant the motion, given the timing. Because I looked at 3.050(1) and the case State versus Chanteloup, 248 Southern 3rd 1191, which was provided to me in the state's response. So I'll hear argument, but address that issue of whether I even have authority under the rules to grant the motion.
Well, just for some background, Judge, Mr. Lopez was charged as a juvenile, and he was sentenced, I believe, to 6 years, followed by a term of probation.
Mm-hmm.
The case that was in front of you, or is in front of you, was a new law violation that violated his probation. The case went up to the 4th PCA, and it was affirmed. And then he came to us with he wanted us to challenge the 3850 for ineffective assistance of counsel,
Right.
which we filed. However, it's in front of Judge Elievich,
Yep.
and she.
You got that right, by the way. That's exactly how she pronounces it.
Getting easy every time. So it was dismissed without prejudice because it was fault. The direct page was faulty because there was a new addition where it said it had to indicate that the person understands English or was translated to him. So we sent it off to Mr. Lopez and the amended direct page. We're not expecting to change the motion itself, but just attach the corrected direct page to the back of it. So we should be filing the amended motion for post-conviction relief with the corrected page shortly. The reason why we're asking for the continuance is because if we filed something here in this case,
Mm-hmm.
it was granted,
Mm-hmm.
and assume that it went to trial and he lost on the merits, then the court could sentence him to a term of prison, and then possibly run it concurrent. I think that's
Possibly what?
run the case concurrent with his 43-year sentence
Right.
that he received in the revocation court.
Okay.
So, as a practical matter, I mean, would it make sense for us to, if we lose on the merits in front of Judge?
I think it's Weiss.
Yes.
Yeah.
In front of the revocation court.
Okay.
Then we might put him in a worse position than what he's in now. So that's the reasoning behind that. And I believe the court does have some discretion in the timing when it's a 3850 motion to adjust the times.
Well, ordinarily, I'd probably agree with you in that the court typically would have discretion in issues of extending deadlines absent a statutory or rule language to the contrary. But the rule seems pretty clear, and given the timing of things, as is stated by the 4th District, thus the burden on the movement is more stringent when seeking to enlarge a deadline that has already lapsed. Well, let me hear from the state. Go ahead.
Okay, Your Honor, the first 2 extensions that were granted, it was because they were out of time. This extension, currently, his response is due on the 8th. So this motion for extension is within the time that the order granting the extension, but the previous two were not.
Right, okay.
And if we continue on this path, it could be 5 years, because he could potentially, he's offering very speculative arguments, and let the state, also put forth that he could go to the Fourth, he could go to the Florida Supremes, and then he could ask the U.S. Supremes.
Yeah,
And it could be 5 years. He's already had 2 years and almost 8 months. The state gets 60 or 90 days, to file a response. He would always be able to withdraw the motion and not proceed on it, or if he needed to amend the motion, because of, the violation of probation cases, he could always do that as well. But we've been sitting on this for almost 8 months.
all right, well, then I'm a little confused as to the relief that you're requesting in the response in opposition, because essentially you say, you ask for me to, in the alternative, find that the defendant should have filed his post-conviction motion in the matter. The deadline was, August 2, but that was before I granted the subsequent
Right.
extension.
Mm-hmm.
So that's, is in essence going backwards. I mean, I don't,
In terms of the motion, I'm sorry that it was confusing. I thought it was very, I wanted to make sure if there was any confusion that we cleared it up.
yeah,
But I understand if you walk out of here today and you're saying you need to file your motion by August 8th, or by, November 8th, it's not really reasonably likely that he's gonna be able to do that. I would agree only if it was 30 days final, get it filed, and that's it.
from today.
Right, because on paragraph C in the wherefore clause, that was kind of what I was thinking, that it would be unreasonable for him to walk out of here and have to file something on Monday.
Okay,
But it needs to be a final extension, because he's had, as I said, 2 years and almost 8 months, and we can't continue this
gotcha.
indefinitely.
All right, here's what I'm gonna do. I'm gonna grant the motion to this extent. I'm going to require, and this is the last, and Ms. Kenny knows, and you've probably seen it too, I do this to her or to the state all the time. This is the last extension I'm giving. The motion has to be filed, the amended motion, second amended motion, if that's the proper title, I forgot. Has to be filed by Monday, December 6th. That gives you a weekend, an extra weekend if you need it, all right? That's a little more than 30 days. Monday, December 6th, okay? That's my ruling. If you want to reduce that to a, to a written, order, that's fine, but that is my ruling, okay? Thank you. And there'll be no further extensions.
Okay. I'll go ahead, the state will go ahead and,
Okay, thank you. All right, anything else, Mr. Casals or Ms. Kenny with me this morning? Okay, both of,
you have a Walker case?
oh yeah, you got Walker later, yeah. No, don't need it. All right, thank you.
But I don't know who opposing
Okay.
counsel is.
Wasn't that Mr. Strecker? Was it? Are you on, you're on Walker, right, or am I mistaken? Okay. Oh, that, you're on Mr. Wallace, right. Okay, all right, thanks. Mr. Paris is over there, though, if you want to talk to him about Walker. In any event, anything else ready yet in the courtroom? All right, back to Zoom. Anybody ready on Zoom? All right, just, speak up if and when something becomes ready. Okay. Okay. All right. Yeah, working, I guess, probably just you're gonna have to get closer to the microphone in all cases. Thank you, Mr. Wallace, for pointing that out. All right, I do have, plea paperwork on Mr. Uptgrow. If that's, oh, okay, Mr. Strecker? No, go ahead, Mr. Strecker, go ahead.
So I have three, Judge, but the only one I'm ready on is, Cintron Santiago, Hector Cintron Santiago on page 2.
All right.
Andrew Strecker on his behalf. Judge, speedy trial was previously waived. I talked to, Ms. Cohen yesterday. The issue in this case is that have been unable to get the body worn camera. We did a request and we did a public records request and I reached out to the officer. So that's really going to be, dispositive as far as a plea, and it's to be clear, it's really, I need to be diligent about getting this. So I do expect that it's very likely that the case will resolve. I know it's been reset several times and it's starting to become an older case, but I really, the contents of that video are going to tell us a lot.
Sure.
It captured the incident, so.
So how much time do you need?
I would ask for another 30 days, and I will make sure that I get this.
Okay. So, December 6th, does that work for you, Mr. Strecker, and does that work for you, Ms. Cohen, who's on?
Yes, it works for the state.
All right.
Thank you, Judge.
Good. All right. 12:06 then, status, or no, well, we'll call it a plea conference.
That's fine.
All right,
Thank
plea
you, Judge.
conference on Mr. Cintron, Mr. Cintron Santiago. Thank you. All right, thank you. Okay, now back to Mr. Uptgrow. Let me get to the right page on the docket. All right, there we go. That's Ms. Overman's case with Ms. White, and we're ready to go. All right, Mr. Uptgrow, to the extent that you can, I know it's not easy, please raise your right hand. Do you solemnly swear or affirm, sir, that the testimony you're about to give to me today will be the truth, the whole truth, and nothing but the truth? All right, great. Lower your hand. How old are you, sir? Okay. And what is the highest level of education you've completed, sir? 10th grade. All right, well, with a 10th grade education, you probably understand what's going on here today. But I have to ask you, do you understand what's going on here today? Okay, got to speak into the microphone. All right. So I'm going to tell you what I think's going on based on the paperwork I've been provided. I'll let you correct me if you think I need correcting. It appears to me, Mr. Uptgrow, from the paperwork I've been given, that you intend to plead guilty to, to admit having violated your probation on which you were placed following a charge of a second-degree felony, felon in possession of a firearm, constructive possession of a firearm, and that in exchange for that admission of violation of probation, I'm going to be sentencing you to serve 364 days, just under a year, in the Palm Beach County Jail, with credit for the 22 days that I'm told you've already served, and that I'm going to be terminating your probation as not having been successfully completed. Is that consistent with your understanding of the deal, Mr. Uptgrow? All right, very well. Am I pronouncing your name correctly? Okay. Okay, good, thanks. All right, so anybody force, pressure, or coerce you in an effort to get you to admit having violated your probation, sir? Okay. You're going to be admitting in a few moments freely, voluntarily, and knowingly then, right? Okay, great. Ms. White, would you please outline the terms of the deal and then give me the factual basis for the admission I'm about to take from Mr. Upgrove?
In case 18 CF 0108442 A and B, he's admitting a violation of probation to felony in possession of a firearm constructive. Besides, waive not required. He's already been adjudicated guilty. He'll pay standard court costs and $200 cost of prosecution and be sentenced to 364 days in the county jail with credit for 22 days time served. He agrees that's the correct amount of credit. Probation is revoked and terminated unsuccessfully. He violated probation, condition number 3, by moving without permission. Condition number 5, for being arrested. It says it has him twice arrested, for one for a felony battery and one for a misdemeanor. He was only arrested for a misdemeanor battery.
Okay,
And then being arrested for driving under suspended license and not completing, his drug and alcohol,
all right.
counseling.
Okay, so, Mr. Upgrove, is that what we've heard Ms. White announce here in open court today concerning the terms of your deal, consistent with your understanding of the deal? Okay. Anybody offer you anything additional or different or better in an effort to get you to admit having violated your probation? Okay. Let's go through a couple of documents together, Mr. Upgrove. The first one through which we're going to go is called a waiver of rights sheet. And, sir, even though it's called a sheet, it's really 2 pieces of carbonless paper. My copy's white. What color is yours, sir? Pink? All right. So on the 2-page waiver of rights sheet, Mr. Upgrove, there are 16 numbered paragraphs. Off to the left of each of those 16 numbered paragraphs, I see the initials CU. Did you put them there? Okay. And a little over a third of the way down on the second page over the line marked defendant's signature, I see some scribbling. I can't possibly read it. Is it, however, your signature that you put there? Okay. And, pardon me, Ms. Overman has signed it as well. I can't read her signature either, but I'm very familiar with it. So, together, the 2 illegible signatures, Mr. Upgrove, and your 16 sets of initials tell me that you and Ms. Overman had the opportunity to go through the waiver of rights sheet together and did so. Is that true? All right. Did Ms. Overman explain the 2-page waiver of rights sheet to you, to your satisfaction, so that you feel as if you understand it? Okay. Have you got any questions about it you'd like to ask me? Okay. So I've got to make sure a few things are very, very clear on the record, Mr. Upgrove. First of all, do you understand, sir, that by admitting having violated your probation in a few moments, you're going to be waiving or giving up the right to an evidentiary hearing at which I would make the decision whether, in fact, you violated your probation? Okay. Do you understand that if you wanted to have that evidentiary hearing, you'd be represented by the very capable Ms. Overman or maybe a different lawyer? But in any event, the lawyer would have both the opportunity and the right to confront and cross-examine each and every witness that the state of Florida, through either Ms. White or perhaps a different assistant state attorney, would be presenting against you. Do you understand that? Okay. Let's see. Was Mr. Upgrove previously adjudicated? Yeah, okay, so obviously, or by the nature of the charge, I should have seen that. Okay, so as a previously adjudicated felon, Mr. Upgrove, you have lost some very valuable rights. Far and away the most important of those rights that you've lost is the right to vote. That one you might be able to get back at some point down the road, but that's up to you to look into. You understand? Okay, next. You've also lost the right to own or possess or carry a firearm or ammunition. That one you're not likely to ever get back. Do you understand that? Okay. All right. Mr. Upgrove, I do not need to know whether you are or are not a U.S. citizen, but if you're not a U.S. citizen, you should assume that the federal government, not Florida, the feds are going to take a look at your deal here. They're going to say, Mr. Upgrove, not a U.S. citizen. We don't want him in the country anymore. We're therefore going to initiate proceedings that will result in his deportation. Do you understand that? Okay, very well. Let's now direct our attention, Mr. Upgrove, to a second document that's on carbonless paper. This one is called Plea in the Circuit Court. My copy, it's only one sheet this time. My copy is white again. What color is yours this time? Yellow, okay. So down here in the lower right-hand corner over the line marked defendant, I see some scribbling. Again, I cannot read it. Is it, however, your signature that you put there? Okay. And Ms. Overman's signature appears on here as well, to the left of yours. So together, again, the 2 signatures tell me that you and she had the opportunity to go through the plea in the circuit court sheet together and did so. Is that the case? All right. Did, Ms. Overman explain the plea in the circuit court sheet to you, to your satisfaction, so that you feel as if you understand it? Okay. Have you got any questions about this one that you would like to ask me? Okay, then. It's very straightforward. Is either side aware of any physical evidence that could be tested that might result in the discovery of exculpatory information that could be used by Mr. Upgrow or on his behalf? All right. Mr. Upgrow, very important question for you, sir. Are you satisfied, sir, with the advice, the services, and the counsel that you've received from Ms. Overman in this matter? Has she, in fact, done everything you've asked her to do defending you in this case? All right. Do both sides stipulate there is a factual basis for the plea, the admission I'm about to take from Mr. Upgrow? Very well. All right, Mr. Upgrow, on the charge that you violated your probation on which you were placed for the charge of previously convicted felon in possession, constructive possession of a firearm, a second-degree felony, how do you plead? Do you admit or do you deny? All right, very well. I accept your admission, Mr. Upgrow. I find that you make it knowingly, intelligently, and voluntarily after your having received the advice, the services, and the counsel of Ms. Overman, with whose advice, services, and counsel you are in fact satisfied. I further find that you understand the nature and consequences of your admission, and I find that there is a factual basis for it. Therefore, in accordance with the deal that you've been able to work out with the state of Florida, with Ms. Overman's assistance, I do re-adjudicate you. I do sentence you to serve, to re-adjudicate you guilty. I do sentence you to serve 364 days in the Palm Beach County Jail. However, I'll give you credit for the 22 days that I'm told you've already served. I hereby revoke your probation and terminate it as not having been successfully completed. DNA is already on record, right? Yeah. All right, so I'm not going to require you to provide DNA here in open court today. The only other thing I have to address is the issue of cost, fees, and fines. I'm told they total $350. What arrangements are going to be made for Mr. Upgrow to pay those? Okay. All right, very well. That relief, as requested, is granted. 10 days upon your release from jail to sign up. Now, depending on what time of day it is, when they release you from jail, you might be able to save yourself a special trip to one of the clerk's offices by signing up out there at the clerk's office at Gun Club. But that's up to you. Now, let me say the same thing to you that all the lawyers in here hear me say day in and day out, Monday through Friday. I wholeheartedly encourage you, Mr. Upgrow, to utilize that community service option. It'll help you by keeping some or all of this $350 in your pocket, and just as important, particularly these days, is the fact that it will help the community in which you and I and everybody in this courtroom reside. Extremely important. All right, anything else on Mr. Upgrow's case? All right, good luck, sir. Thank you. All right. Anybody else ready here in the courtroom? Good morning.
Sorry, I forgot my tie this morning, Your Honor.
That's okay.
I'm here on Leonard Persin.
Okay.
I'm actually here just on the infraction portion of the case, which is page 5.
Okay.
Yeah, I spoke to him. He's out in the hall, Your Honor. Mr. Bear apparently represents him on the felony charge.
Okay.
He also filed a notice of appearance on the traffic ticket.
Okay.
But Mr. Persin retained us also for the traffic ticket, so we want to just withdraw off the case. Mr. Bear can remain on the whole thing. So
Sure.
Mr. Mumford would like to withdraw,
All right.
if possible, so we don't.
That's the only reason for which we're here today? No. Case
No,
is-
the
status. Okay.
criminal check case is up as well.
All right, Mr. Mumford, I'll grant your motion to withdraw, given the fact that there's been an appearance on both cases by Mr. Bear.
Yes, I'm Corey Hauser. I'm standing in for Mr.
Oh, I'm so sorry.
It's okay. I
All
just
right.
wanted to.
What's your last name?
Hauser?
Hauser. Okay, Mr. Hauser, thank you.
All right, so do you want an order, Your Honor, or?
Yeah, just to be safe, yes,
Okay,
please.
thank you.
Thank you. All right, but we're not ready to go. Mr. Bear, or no one from Mr. Bear's office is here to, on this, okay, very well, thank you. All right, anybody else ready in the courtroom or on Zoom? No, okay. I only signed in on the one.
Yeah, that's why I have to have you.
Okay, all right. Good morning.
Good morning, Josh. How are you doing?
I'm great. You?
I'm doing well. You know,
Good.
it's Friday, I'm getting better by the minute.
There you go.
Rob Melker here today on behalf of James Walker, covering
Okay.
for Paul Walsh.
Sue Ellen Kenny on behalf of the state.
Okay, thank you.
And we need to set this for an evidentiary hearing. We're speaking with Mr. Walsh.
All right, so how many days do you think, or, no, I'm not doing that to myself. How much time do you think that this evidentiary hearing is gonna take?
I'm gonna have at least 2 witnesses.
Okay,
I'm not sure how many Mr. Walsh will have. He told me he anticipates around 3 to 4 hours.
okay, so an entire afternoon then.
I believe he is.
Right. Right, so we need,
Okay?
this is not the one that we discussed briefly yesterday, obviously.
No,
Okay.
no, that's,
So there's no order to transport yet entered. Okay, gotcha. All right, well, submit that quickly as you can. I'll sign it, and then we'll set it for a status check. When, Steph?
Okay.
All right. Okay. Let's call it, is one or the other better for you, December 6th or December 7th?
Either way, the court's pleasure.
All right, December 7th then, status check on Mr. Walker. We'll see where he is. He's in custody. No, wait a minute. How come it doesn't say he's in custody?
Because he's not here in custody, that's the problem.
Oh, he's in DOC. I've never noticed that before. So if somebody's in custody, if it says in custody, that means Palm Beach County Jail. Got it. Okay, all right, got it. Okay, so,
That will be done. I know Mr. Walsh is out today, but that will be done at the beginning of next week.
okay, very well. All right, PD move to withdraw? Thank you. All right. And let's see, Mr. Persin. Okay, very well. All right, thank you. I'll be looking for that, order to transport. Thank you. Okay, that was Mr. Walker. Anybody else ready here in the courtroom on anything? Good morning, Ms. Wilson. Let's see. I don't see,
Andrew Wallace, Judge.
okay, there we go.
And
Thank you. All right, and Mr. Wallace is appearing via Zoom. He's up there in the upper right corner of the big monitor.
yes, Judge, Andrew Streck on behalf of Andrew Wallace.
And my victim is coming, they were put out just because we weren't calling it up, so I believe her and her attorney are coming right now.
Oh, okay, thank you.
Judge, the state has filed an amended information. There are no new charges added, but the state changed the subsection of the statute for the felony count 1. So I talked to my office already this morning, and they're going to be filing a waiver of arraignment
Okay,
on that case, because I don't think it's, I believe it was filed this morning.
It was just filed this morning.
So I don't
I
think.
notified them, but it still might not be up yet.
So I don't think that precludes us, since it's just a change, I don't think that precludes us from going forward with the
okay,
motion to modify release conditions.
all right.
You heard on that?
Yes, of course. I did read the motion, so keep that in mind.
And, Your Honor, just very briefly, we are seeking, release conditions which are not house arrest. So either a monetary bond, an SOR, or a monetary bond. I have some brief testimony to offer from, Mr. Wallace. So if I could call him.
Sure. He is on Zoom. Mr. Wallace, unmute your, there you go. Please raise your right hand, sir. Do you solemnly swear or affirm, sir, that the testimony you're about to give to me today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, great. Lower your hand. All right, you may inquire, Mr. Strecker.
Mr. Wallace, does the house arrest restriction make it difficult to comply with the terms of your court-ordered parenting plan?
It makes it nearly impossible to comply with the terms of the court-ordered parenting plan. I've had to ask multiple third parties to pick up the children from school, and am unable to facilitate our normal routine or parent to my fullest potential.
Does the house arrest restriction make it difficult for you to seek employment?
It makes it extremely difficult to seek a salaried position, and it also eliminates my ability to earn income through the gig economy while I search for new career opportunities.
If the house arrest restriction were to be removed, do you understand that any contact whatsoever with the victim in this case, Lindsay Wallace, would lead to your immediate incarceration with no bond?
I do.
And could you briefly describe your family connections to Palm Beach County?
I'm a homeowner in Jupiter, and I have 2 young children that attend school in the township, and my parents are primary residents of Florida and live in Palm Beach Gardens.
Mr. Wallace, the last time that you were notified that there was a warrant for your arrest, what did you do?
I turned myself into Palm Beach County Jail Main Detention Center in West Palm Beach.
If released from the in-house arrest restriction, would you attend all future court dates as ordered by this court?
Absolutely.
Those are all the questions I have, Judge.
All right, thank you. Any cross-examination, Ms. Wilson?
Yes, Your Honor.
Okay, go ahead.
Mr. Wallace, that child care plan, was that put in place before, you were incarcerated for the cases that we're here for today?
I'm sorry, could you repeat the question?
When did that child care plan get put in place?
Yes, the custodial plan was put in place prior to the additional charges that were filed by the state.
Were they also prior to you being found guilty of the underlying misdemeanor charge?
They were, but I do have an appeal pending with the 4th District Court.
Not what I asked, so it was before that, though, yes?
Yes, ma'am.
All right, as far as trying to look for a job, are you unable to go and do interviews because of in-house arrest?
That is correct.
So in-house arrest will not allow you to go to pre-planned interviews?
That is correct. That is what the deputy communicated to me. She said the only thing that I am excused to do is to attend court, attend my lawyer's office, or go to medical appointments. I specifically asked about attending jobs interviews, and she said unless it's pre-approved by the judge, I would not be allowed.
I have no further questions.
All right, any testimony based on the questions by Ms. Wilson?
No, Your Honor.
All right. Let me hear argument, please.
And what, Your Honor, I have Ms. Lindsay Wallace.
Oh, all right, come on up, Ms. Wallace. All right, please get close to the microphone. Raise your right hand, ma'am. Do you solemnly swear or affirm, ma'am, that the testimony you're about to give to me today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, great. Lower your hand. You may, would you please say and spell your first and your last name for the record?
Lindsay Wallace, Lindsay, Wallace, Wallace.
That's why I always ask. I would have spelled it differently. Okay, go ahead, Ms. Wilson.
Thank you, Your Honor. Ms. Wallace, do you know Andrew Wallace?
I do, yes.
And how do you know him?
We were married.
Okay. And how many children do you have?
We have 2 children,
What are their ages?
7 and 9.
Okay. Ms. Wallace, are you the victim both on the domestic misdemeanor case and on this case?
Yes, ma'am.
Okay, so you are aware that the defendant was released in October, is
Yes.
that correct?
Yes, I am.
I just want to talk about a couple instances that have happened since that time. And I've given a copy of this to opposing counsel. And Your Honor, may I approach?
Sure.
so just hold on to that.
Yep, thank you.
Ms. Wallace, what are we looking at here?
This is a screenshot that I took from my work phone of a group text message.
Okay, now, as far as this injunction and no contact order, is Mr. Wallace allowed to contact you at all?
No, not in any way.
Okay, it looks like it's coming from a group chat. When was this group chat started?
So this is a group chat that was started by my mom in May 2019 and ended in May 2019, with the exception of this message.
Okay, so what was the purpose of that group chat?
My brother had just graduated.
And I see a message here. Who's that message from?
Andrew Wallace.
And so, again, I just want to clarify, when was the last time that group chat was used?
May of 2019.
And then finally October of 2021?
Correct.
Okay. And then one more. And we'll have to have a copy of this as well. So what are we looking at here?
This is a screenshot from my daughter's iPad.
Okay. How does your daughter use the iPad, or what does she use it for?
Well, she's 9, so she uses it for mostly to talk with her friends, but when she is with her dad, she's supposed to be able to use it to contact me every night or whenever she pleases, and conversely, for her to talk to him when she's with me.
Okay.
And for my son as well.
So that way you're not having contact with each other, you're
Correct.
just having contact with your children.
That's right.
So what are we looking at here?
So this is a screenshot of the app Find My Location. This October 31st, my daughter was at her father's house, and this is a search of my location from her iPad, a function that she does not know exists or know how to use.
Okay. And when you first saw this, what was your fear? What's your belief as far as this goes?
I mean, my immediate concern and fear is that Andrew is cyberstalking me again.
I'm gonna object to hearsay, Judge. I don't know where this came from. I don't think that she can authenticate this, and essentially these are statements from her daughter.
Want to be heard on the hearsay objection? Well, it's a combination, hearsay and authentication. Go ahead.
Your Honor, it's a bond hearing. The victim has testified that she pulled it off her iPhone. I'm not using this to ask for more bond, but this isn't for a basis to revoke bond. However, it's to go against opposing counsel's arguments that he should be let out to do as he wishes.
I'm objecting to them being admitted into evidence, is my objection.
All right. I'm going to sustain the objection, however, and these will not be admitted into evidence. However, I'm going to overrule the hearsay objection and allow Ms. Wallace to continue to testify. Go ahead.
Okay, we were talking about, or you heard your husband talk about this family share plan. When was that plan put in place?
That was put in place in March of 2021, earlier this year.
And were there violations based on that plan after it was put in place?
Yes.
And what sort of communication did it allow for?
Within the time sharing, there's specific restrictions on using Family Wizard's business-like tone to communicate only about the children's welfare and interests, and otherwise no contact whatsoever.
And were there violations based on that?
Yes, there were.
Okay. And again, this family share plan, was that before all of these violations that make up the felony case?
Yes, ma'am.
And were they before he was found guilty of the misdemeanor case?
Yes, at that time that was still pending.
As far as family sharing, or is there other courts that are dealing with that at this time?
Yes, the family courts and the civil courts.
Okay, so on November 18th, what sort of hearing do you have set for that?
There's an injunction hearing on November 18th to address some of the time sharing concerns.
Okay, and then,
Sorry, an injunction hearing to determine what?
Sorry, I'm not a lawyer, so I don't know the appropriate terms, but we're attempting to address time sharing within the injunction.
To modify time sharing?
Correct.
All right, got it.
and then December 2nd, what sort of hearing do you have there?
So we also have a hearing on December 2nd with the family courts under Judge Miller to address the time sharing agreement.
I have no further questions.
Thank you. Any cross?
Just briefly, Judge.
Sure.
This, screenshot, the one that has, Mr. Wallace's location, when was that shared with this group text?
That was on the 30th of October.
During the course of your marriage, did you ever, share locations, with your husband as part of text messages?
No, not to my recollection.
Okay, and, as far as the, no contact orders, that are currently in place against Mr. Wallace, those no contact orders, specifically do not provide, they specifically do not, they allow contact between Mr. Wallace and his minor children, isn't that true?
I'm so sorry. Can you just repeat the question? I'm not sure I understood you.
The contact orders that are in place, in, the injunction, and the criminal case, they allow contact between Mr. Wallace and his children, is that right?
I don't know if the injunctions address that. I think it's that the time-sharing agreement allows for contact.
Okay, and during the period of time that Mr. Wallace has been on house arrest, he has, exercised time sharing with his children, is that right?
Yes,
So the children have had overnights with Mr. Wallace during this period of time.
correct.
During the period of time that this, location was shared, was that during a period of time that Mr. Wallace, had the minor children in his care?
Yes.
Do the minor children ever use, your devices when they're with you?
I'm sorry. Do what?
Do the minor children ever use your Apple devices when they're with you?
On occasion with my permission, but I have my phone password protected.
Those are all the questions that I have to.
All right, very well.
Just a
Okay, go ahead.
direct, sorry, Ms. Wallace. Do you know of the kids ever using, the defendant's iPad, or iPhone, excuse me?
I can't speak to that recently, but to my, recollection, no, he's got that password protected and they have their own devices to contact me.
So the kids each have an iPad?
They do. Only Elizabeth had her iPad with her, on those dates, but yes, they do each have an iPad.
Okay. I have no further questions.
All right, very well. Any additional testimony or evidence of any kind?
No testimony, Judge, just brief argument.
All right, go ahead.
Judge, I just would like to, it's contained in the written motion, but I would just ask that the court take note of the fact that the parties were married for 10 years, they continue to be married, they have 2 minor children in common. The state has alleged a felony based on the allegations, if true, are that during the period of time that there was no contact order that Mr. Wallace made during a period of time based on the state's amended information between March 27th and April 5th, so about a 9-day period of time, that Mr. Wallace sent flowers, held up a sign during FaceTime. Essentially, the contacts that are alleged were Andrew Wallace attempting, if true, attempting to reconcile with his wife of 10 years. What we're asking for is less restrictive terms so that Mr. Wallace can take care of his child care duties and can seek gainful employment. And the house arrest restriction is currently stopping him from doing that. There are less restrictive terms than house arrest, which would ensure the safety of the community, but there's been no testimony about any threats of violence against Ms. Wallace. So what we're asking for is a monetary bond and some type of SOR, which would allow Mr. Wallace to take care of his child care responsibilities, and that includes getting gainful employment so that he can help support his children. So what I would be asking for is a $5,000 total bond, I'm not sure. So I guess I'd be asking for $5,000 on count 1 and then SOR, on counts 2 through 11. I think that, I also would like the court to consider that when arrest warrant was in place for Mr. Wallace, and he was notified about it, he self-surrendered. I don't think that there's any indication that he is a flight risk. And I think that there are less restrictive terms than house arrest, which would provide for the safety of the community.
All right, thank you, Mr. Strecker. Ms. Wilson?
So, Your Honor, I think because it's one giant case, it makes it a little bit convoluted about what happened. In this case, he was given a criminal no contact order. He was given a civil injunction and violated multiple times. And previous to me consolidating this was 4 separate cases. So we have a case where he is given a warrant for the case, you made contact, and he makes contact again, over and over and over again. And I'd point out that previous to my consolidation, this was actually a $300,000 bond plus in-house arrest. That's what the bond was set at. When it got to first appearances, there was a mix-up. The probable cause affidavits, all of them were not put in together, and so it seemed like it was just one incident. While I'm not asking for a higher bond because of this, I do want you to take that into account. You heard Ms. Wallace's testimony. We have a text message that was sent from the defendant's phone from a conversation in 2019. Could it be the children? Maybe, but given the continued behavior of the defendant, at least what's alleged by the state, I would suggest that the defendant did that. Also, the Find My iPhone, which is even more concerning because he wants to know where she is. The victim's in fear. She's testified multiple times that she's in fear of the defendant. And really the only way to ensure that she is going to feel safe during the pendency of this case is to keep him on in-house arrest. And as far as the family plan goes, it's going to be addressed by another court, and to set it up so that he is out to do all these things based on something that was put in place before all of these violations and him being found guilty of the case would just, I think it's too early to decide that, Your Honor. So we just ask that you keep the bond set as is.
All right, very brief rebuttal, if any.
Yes, Judge. I was the attorney at first appearance in front of Judge Kasternakis. I believe that Judge Kasternakis was made fully aware of all of the facts and circumstances and ordered in-house arrest at that time. I also would like the court to consider the fact that there have been multiple no-contact orders issued in this case, but as pursuant to a DCF investigation, there was no finding that the children were involved in any way. There's been no allegation of neglect or abuse, and he has been making great efforts to fulfill his time-sharing obligations. He just is limited in what he can do by house arrest. So there's been no issue with safety or his ability to care for the children. Those criminal charges were pending when DCF investigated. So as far as, and that's for another court, but as far as the facts in this case, even if true, I don't think that these allegations warrant in-house arrest as the only release conditions for these charges.
All right, thank you. Before I make my ruling on this, I want to admonish both sides, the Department of Children and Families have enough to do without getting involved in custody battles. So that's what the family court and the criminal courts are for. I just admonish both sides to that. I have no idea what allegations were made in terms of abuse reports, but keep that in mind, please. Now, with respect to this motion, we're to grant it to this limited extent. I am going to order that while Mr. Wallace remains on in-house arrest, he is to be permitted to go to specifically enumerated and identified interviews for employment. He is to get the permission of the supervising authorities for each such appointment or interview with specificity so that the time of the interview is established. He has to identify the person or persons with whom he is going to be interviewed or by whom he's going to be interviewed, and the time and location of and date, obviously, of the interview. He's to go if in fact he has an interview at a particular location. He is to go directly to that interview, sit for the interview, and then return directly home. No side travel, if you will. The no contact orders remain in full force and effect. This ruling is without prejudice to another motion, depending on how Judge Miller rules in the family court hearings coming up in the later part of this month or middle of this month, I gather, and the early part of December. All right, anything else on Mr. Wallace's case?
No, Your Honor, I'll prepare an order.
Thank you. Oh, yes. All right. So you said December, well, your witness testified December 8th is the next hearing in front. Do you have any clue? Counselor, do you have any clue when Judge Miller will be ruling on that December 8th hearing?
I thought it was I'm
Oh, well, maybe it is the third. I heard eighth.
I'm the attorney on that case.
Okay, fine, then I can,
I thought it was the third, and, I wouldn't want, I mean, as the court knows, sometimes in family court hearings, the order doesn't come until,
yeah, that's what I'm concerned about. Well, I heard the eighth, maybe I misheard. All right, so, yes, ma'am. Well, first of all, notice yourself for the record, if you will, please.
Certainly. Your Honor, my name is Samantha here. I'm Lindsay Wallace's attorney.
Okay.
For her injunction case.
Okay,
We have a motion set on the 18th of November before Judge Gerber.
okay,
A motion to extend the injunction and modify the conditions. There's also, a family law case, and off the top of my head, I apologize to the court, it's either December 2nd or December 3rd.
okay.
There is a temporary release hearing before Judge Miller.
Gotcha. All right, so, thank you very much, Counselor. So, after, my ruling in today's, on today's motion is without prejudice to your filing another motion once you have received, rulings from, Judge Miller and Judge Serber, okay? All right, thank you very much.
Can I ask a clarifying question? So time sharing wasn't addressed at this point?
The latter part of December, by then, hopefully, well, let's make it January 7th. January 7th. Whether you filed another motion or not by then, I just want to see where we are. Okay? Speedy, are you in a position to waive speedy?
I unfortunately am not.
Okay.
He has run on the misdemeanors. I'm not sure where we are with the felony. I just took Ms. Wallace's deposition, but unfortunately, I'm not in a position to waive speedy at this time.
All right, so,
If he doesn't want to waive speedy, Your Honor, I'd ask for a December calendar call.
well, I'm not going to set a calendar call, but I am going to set the status check earlier than January 7th. Whether, Judge Miller has ruled or not, we're going to hear this case, I'm going to hear this case on December 23. December 23, status check on Mr. Wallace. Okay?
Thank you, Your Honor.
Thank you both, or all, I should say. Thank you all. All right. Let's see here. Go ahead.
Good morning, Your Honor.
Morning.
Shervin Muhammad, Greg Rosenfeld on his behalf. That's page 3 on the court docket. Mr. Muhammad's in the hallway.
All right, thank you.
This is gonna be a agreed reset for a plea conference.
Okay.
I'd request November 22nd if that works for Ms. Cohen.
Ms. Cohen, did you hear that? No. Okay. Oh, yeah, we can't do it then. That's, 23rd I can do. Well, she's not available the 23rd.
Yeah,
Cohen is.
yeah.
So, okay, 30th.
Perfect.
All right. November 30th.
Thank you. Thank you.
Thank you for a plea conference on Mr. Mohammed's case. And since he's out in the hall, you will, notify him, Mr. Rosenfeld?
Yes, Your Honor.
All right, thank you very much.
Thank you very much. Have a great day. Great
You,
weekend.
you too, thanks very much. Stay safe. Okay, good morning.
Good morning, Your Honor. Ralph Baer before the court on the matter of State versus Leonard, Persin, P-E-R-S-I-N.
All right.
Page 5. Mr. Persin is in the corridor and is here for a change of plea.
Okay. All right. That was this one then. All right, very well, thank you. So let's get Mr. Persin in then, please. Yes. Is that Mr. Persin?
Yes, it is.
All right, very well, thank you. All right, come on up, Mr. Persin, please. All right, Mr. Persin, please raise your right hand. Do you solemnly swear or affirm, sir, that the testimony you're about to give to me today will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
All right, great. Lower your hand. How old are you, sir?
51,
Okay. What's the highest level of education you completed, sir?
1 year.
1 year of college? Okay. So you don't have a degree. Nevertheless, with 1 year of college under your belt, you probably do understand what's going on here today. But I'm going to ask you anyway. Do you understand what's going on here, Mr. Persin?
Yes, sir.
All right. So the paperwork I've been provided leads me to conclude that you intend to plead guilty to the charge of the first-degree misdemeanor charge of possession of drug paraphernalia for your own personal use. Is that in fact what you intend to do?
Yes, sir.
All right. And that, I anticipate, well, I'm being asked essentially to adjudicate you guilty based on that guilty plea in a few moments, to sentence you to 2 days to be served in the Palm Beach County Jail, but with credit for the 2 days that I'm told that you've apparently already served. So there's no additional jail time. It's essentially a time served plea. Is that consistent with your understanding of the deal?
Yes, sir.
All right, very well. Pardon me. All right, Ms. Black, would you please outline the terms of the deal, then give me the factual basis for the plea I'm going to be taking for Mr. Person?
Case number 21CF002815, the defendant's pleading guilty to possession of paraphernalia use, lesser included charge of first-degree misdemeanor. PSI is waived, not required. He is to be adjudicated. He's to pay standard court costs and fines, including the $100 cost of prosecution. He's sentenced to 2 days in Palm Beach County Jail with credit for 2 days, and he agrees that 2 days is the correct amount of credit and waives any affirmative right to appeal. As far as the factual basis goes, on April 3rd, 2021, officers are patrolling in Delray Beach. At that time, they noticed that the defendant failed to come to a complete stop at a stop sign. Subsequent to initiating the traffic stop, they smelled the odor of marijuana and searched the car and found paraphernalia. The defendant can be positively identified in these events occurred in Palm Beach County, Florida.
All right, thank you very much, Ms. Black. Mr. Person, back to you, sir. Are you, is that which we've all heard Ms. Black announce here in open court today concerning the terms of your deal consistent with your understanding of the deal?
Yes, sir.
All right, anybody promise you anything additional, different, better, sweeter in an effort to get you to plead guilty to possession of drug paraphernalia?
No, sir.
All right, very well. Let us direct our attention, Mr. Person, to a couple of documents. The first one we're going to discuss is called the waiver of rights sheet. Even though, Mr. Person, this is called a sheet, it is comprised of 2 pieces of carbonless paper. My copy, as you can see, is white. What color is yours, sir?
Pink.
All right, so on this 2-page document, Mr. Person, there are 16 numbered paragraphs. Off to the left of each of those 16 numbered paragraphs, I see initials, I guess they could be LP. In any event, did you put those initials there?
Yes, sir.
All right. And a little over a third of the way down on the second page over the line marked defendant's signature, I see a signature I cannot read. Is it your signature, though?
Yes, sir.
Okay. And Mr. Bear has signed it as well. I can't read his signature, but as an officer of the court standing there, he would tell me if that were not his. Therefore, the 2 signatures and your 16 sets of initials, Mr. Person, tell me that you and Mr. Bear had the opportunity to go through the waiver of rights sheet together and did so. Is that true?
Yes, sir.
All right. Did Mr. Bear explain the waiver of rights sheet to you to your satisfaction so that you feel as if you understand it, sir?
Yes, sir.
All right. Have you got any questions about it you'd like to ask me?
No, sir.
Okay. Very well. So I got to make sure a few things are crystal clear on the record, Mr. Person. First of all, do you understand, sir, that by pleading guilty in a few moments to this possession of drug paraphernalia for your personal use charge in a few moments, you're going to be waiving or giving up the right to a trial by jury?
Yes, sir.
All right. Do you understand, sir, that if you wanted to have a jury trial, you'd be represented by Mr. Bear or maybe a different lawyer? But in any event, the lawyer would have both the opportunity and the right to confront and cross-examine each and every witness that the state of Florida, through either Ms. Black or maybe a different assistant state attorney, would be presenting against you. Do you understand that?
Yes, sir.
All right. Next, do you understand that if you wanted to have a jury trial, you would consult with Mr. Bear on the question whether you wish to testify in that jury trial? You might decide to testify, but you might decide not to testify. And if you were to decide not to testify, I or whatever judge would be presiding over your jury trial would turn to the ladies and gentlemen of the jury who would be seated right over there in that great big box where those 3 folks are now seated, and I would say to them, ladies and gentlemen of the jury, you cannot hold Mr. Person's decision not to testify. In other words, you cannot hold his silence against him in any way, shape, or form. Do you understand that?
Yes, sir.
All right. Next, do you understand that in order for you to be convicted of this charge, the state of Florida would have to prove each and every element of it beyond a reasonable doubt? You understand that?
Yes, sir.
All right. And finally, Mr. Person, do you understand that if you decided to have a jury trial and you lost, you'd still have the right to appeal to a higher level court? Understood?
Yes, sir.
All right. So, in spite of all those understandings regarding jury trials and your right to have one, it is your decision, your intent this morning to plead guilty to this possession of drug paraphernalia for your personal use charge, a first-degree misdemeanor, and thereby waive or give up your right to a trial by jury, correct?
Yes, sir.
All right. Very well. I'm assuming, well, I shouldn't. Okay. Thank you. So, Mr. Person was not previously adjudicated a felon. He's not going to be today. Let us keep it that way, Mr. Person. You don't ever want to become an adjudicated felon. So the good news is I can skip down to this. Mr. Person, I do not need to know whether you are or are not a U.S. citizen. But if you're not a U.S. citizen, you should assume, sir, that the federal government, not Florida, the feds are going to take a look at your deal here. They're going to say, hey, Mr. Person, not a U.S. citizen. We don't want him in the country anymore. We're therefore going to initiate proceedings that will result in his deportation. Do you understand that?
Yes, sir.
All right, very well. Let's now, Mr. Person, direct our attention to a second document on carbonless paper. This one is called Plea in the Circuit Court, and it is comprised of only one sheet. My colleague copy again is white. What color is yours?
Pink.
Pink again. All right, so down here in the lower right-hand corner, over the line marked defendant, I see a signature, which again, I cannot read. Is it yours, though?
Yes, sir.
All right, very well. And Mr. Bear has signed it as well. So together, the two signatures tell me again that you and Mr. Bear, have the opportunity to go through the plea in the circuit court sheet together and did so. Is that true?
Yes, sir.
All right. Did Mr. Bear explain the plea in the circuit court sheet to you to your satisfaction so that you feel as if you understand it, sir?
Yes, sir.
All right. Any questions about it you'd like to ask me?
No, sir.
Okay, very well. It's very straightforward. Is either side aware of any physical evidence that could be tested that might result in the discovery of exculpatory information that could be used by Mr. Persin or on his behalf? All right, Mr. Persin, very important question to you, sir. Are you satisfied with the advice, the services, and the counsel that you have received from Mr. Bear in this matter?
Yes, sir.
Has Mr. Bear in fact done everything you've asked him to do, defending you in this case?
Yes, sir.
All right, very well. Do both sides stipulate that there is a factual basis for the plea I'm about to take from Mr. Persin? Very well. All right, Mr. Persin, on the charge that you were in possession of drug paraphernalia for your personal use, a first-degree misdemeanor, how do you plead, sir? Guilty or not?
Guilty to the misdemeanor.
All right, I accept your guilty plea. I find that you make it knowingly, intelligently, and voluntarily after your having received the advice, the services, and the counsel of Mr. Bear, with whose advice, services, and counsel you are in fact satisfied. I further find that you understand the nature and consequences of your guilty plea, and I find that there is a factual basis for it. Therefore, in accordance with the deal that you've been able to work out with the state of Florida with Mr. Bear's assistance, I do adjudicate you guilty. I do sentence you to serve 2 days in the Palm Beach County Jail. However, I will give you credit for the 2 days that I'm told you've already served. Therefore, there's no additional jail time. The only other thing I believe I have to address is the issue of cost, fees, and fines. I'm told they total $338 in this case. What arrangements are going to be made for Mr. Persin to pay those?
Plan on paying them today.
All right, very well. So that means that as soon as you're released from the courtroom here today, you'll go downstairs to the third floor and pay those court costs.
Yes, sir.
All right. Anything else on Mr. Persin?
Yes, Your Honor, with the court's permission, there was a traffic infraction issued simultaneously or contemporaneously. We'd like to see if we could resolve that today.
Leave up to the judge's discretion. He ran a stop sign.
All right. I'll dismiss those charges. All right? All right, you're welcome. There we go. Mr. Persin. Okay, I see paperwork, is Mr. Vesey's case yours, Mr. Ryan? No, well, that's fine, I could take whatever you had for me. Okay.
On page 4, Judge.
All right. I'm there, thank you.
This is set for defense motion to modify release conditions. The number in bond is currently set at $500,000 with an additional condition of in-house arrest.
Okay, I read the motion, and I also read the probable cause affidavit, which is substantial, but there's much more information about other individuals than there is about Mr. Nemerin. So keep that in mind, please, when you're making your presentation. Are you going to have Mr. Nemerin testify or no?
No, Judge.
All right, very well. All right, go ahead.
Your Honor, Mr. Nemeren's bond is currently set at $500,000 with an additional condition of in-house arrest. I was retained by his sister. His sister is ready, willing, and able to have him reside at her residence. But the $500,000 bond condition is tantamount to no bond. I believe Mr. Nemerin has previously been found indigent. He was not employed at the time of his arrest. So, what I would be asking for is, and SOR released with the monetary conditions. The state can enlighten us on the facts of, his history. He does have, some priors, however, there are no actual new predicate offenses except for the racketeering allegations. Mr. Nemerin, I believe, only has one failure to appear when he was 18 years old, and, there's been no motion for pretrial detention filed or no, grounds for that, so he, for an indigent person, $500,000 bond, it means that he cannot be released pretrial. So, I would be asking, if the court, is inclined to either just give him a monetary bond plus SOR, or the alternative, give him in-house arrest, with no monetary bond. Thank you, Judge.
All right, Mr. Ryan?
Yes, sir. So I guess as a threshold question, we've had no testimony regarding Mr. Nemorin's actual finances at this point, so I don't, we can't really delve into that to see what he can and cannot afford. That is an important consideration. To that end, Your Honor, I have provided to defense this morning, throughout the investigation of this case, Instagram was subpoenaed and they sent over a plethora of files on all the defendants. In this case, Mr. Nemorin being one of them. I've created a composite one, exhibits A through L, I'd like to present to the court at this time, showing Mr. Nemorin with access to a fair amount of money. That account has been linked to Mr. Nemorin through Instagram in a subpoena. So, say indigent for cost, he may not have a job, but he definitely has access to money. All of his priors that are predicate offenses in this case are sales and/or traffickings and/or maintaining a trafficking residence. He got out of prison in December of 2019. So given that, Your Honor, in all candor to the court, there was one of his co-defendants did have a prior bond motion in front of Judge Weiss, that's Mr. Moslot Joseph. She reduced his bond to $100,000 per count and kept all the conditions in place. So I think that's illuminating. I'm asking to keep it as it is, but that's the current layout for the rest of the co-defendants in this case. So given that information of regard to Your Honor and its history, the state's asking to keep it as it is.
All right.
Judge, I would just ask the court to consider that he's previously been found indigent. So, and as far as the pictures, I did have a chance to review them. I only saw them this morning. I was not present at the bond hearing on the co-defendant, but it's my understanding that Judge Weiss did not consider the Instagram photos. I don't know that we know when they were taken. I don't think there's any testimony that we don't know if this is prop money. Even in the probable cause affidavit.
You don't know if it's what money?
It's called prop money.
Prop money?
In
Yeah.
music videos, they use,
Okay.
firearms or money that are not real, but look real. They use this in movies or music videos.
Okay.
I think it's even contained in the probable cause affidavit that, there's a entity that's incorporated on Sunbiz, and they're some of these, young men are musicians or have, had, earned some income from the music business. So without knowing when those pictures were taken, whether or not it's real money, I don't think that there's anything that the state has done to establish that he's not indigent if he's already been previously found to be indigent. So
How long ago was it when he was found to be indigent?
I believe he was found indigent in this case, Judge, because he originally.
This case?
He was originally, represented by either ORCC or the public defender.
Well, that was probably at